Enter the 119th Congress and the Free Speech Fairness Act. The specified goal of this act is allowing 501c3 organizations to make statements relating to political campaign in ordinary course of carrying out its tax-exempt purpose. Isn't this nice? Congress wants to allow 501c3 organizations to exercise their free speech rights. Maybe that title is just poorly worded. Maybe the language of the legislation will be better. In general, for purposes of subsection C3 and sections 170C2, 2055, 2106, 2522, and footer 955, an organization shall not fail to be treated as an organized and operated exclusively for a purpose described in subsection C3, nor shall it be deemed to have participated in or intervened in any political campaign on behalf of or in opposition to any candidate for public office solely because of the content of any statement which, A, is made in the ordinary course of the organization's regular and customary activities in carrying out its exempt purpose, and B, results in the organization's incurring not more than a de minimis incremental expense. Should this legislation pass both houses of Congress and be signed by the President, we will trade one somewhat vague standard for another. Don't get me wrong, I love the idea of Congress no longer trying to use the threat of revoking tax-exempt status because one senator was getting beat up by a couple of charitable organizations. But I think this could be better. For example, the current standard for a religious or charitable organization to express their opinions about legislation or candidates is no substantial part of their activities. Tell me, what constitutes a substantial part of activities? Is it the amount of time spent, the amount of money spent, or just what some bureaucrat thinks is advantageous at the time? This gets replaced by the ordinary course of the organization's regular and customary activities. What are the ordinary course of activities for a religious organization? And who decides what is ordinary and what isn't? A minister speaking from a pulpit seems like an ordinary activity to me, but what if that same minister speaks at a rally or legislative committee hearing? If a charitable organization serves meals in a building they own or rent, that seems like an ordinary activity. But what if they do so in a public park? Then there's a question of de minimis incremental expenses. This is a legal term for something so small the law doesn't care about it. For example, in a $1 million deal, a $10 mistake is considered de minimis. So what is a de minimis incremental expense? Is it 1% of the organization's budget or 10? Is it $100 or $1 million? Once again, it appears Congress wants to pass a vague law and let the executive bureaucracy fill in the blanks. And we've seen how that's worked over the years.